philosophy.
I'll give a little more background just so that, so Robert Howse is the Lloyd C. Nelson Professor of International Law at NYU School of Law. He received his BA in Philosophy and Political Science with high distinction, as well as an LLB from the University of Toronto, where he was co-editor-in-chief of the Faculty of Law Review. He holds an LLM from Harvard Law School as well. He's been a visiting fellow at the London School of Economics, visiting professor at Harvard, Tel Aviv University, Hebrew University of Jerusalem, University of Paris, Tsinghua University, and Osgoode Hall Law School in Canada, taught in the Academy of European Law, European University Institute Florence, and he also taught a one-week course in the Faculty of Law at Haifa here a couple of years ago. He's been a member of the faculty of the World Trade Institute, earned his master's in international law and economics program, frequent consultant or advisor to the government agencies and international organizations, such as the OECD, the World Bank, UNCTAD, the Inter-American Development Bank, the Law Commission of Canada, the UN Office of High Commissioner for Human Rights, and there are many, many other things. He's the co-founder and co-convener of the New York City area group on international economic law, serves on the American Bar Association working group on investment treaties, numerous editorial boards, and he is the author, co-author, and co-editor of numerous books, including Leo Strauss, Man of Peace, Trade and Transitions, and I think I'm going to stop there. This is Itamar Mann, another PI of the center.
I just wanted to apologize. We had a protest outside against the dissolution of the rule of law in Israel, and the students were very active. We were answering questions, and it was took a little bit of time.
No problem.
Sorry.
It's a good cause.
With the shirts?
We were there with the shirts, and we were, yes.
Because we were told that we weren't going to do it this week.
No, there was a very large protest this week, and it was very nice, yes.
Okay. So, and Robert's going to talk about, should states be liable under investment agreements for failure to prevent non-state actor violence in conflict zones? A skeptical view, the case of Ampal versus Egypt. Thanks.
Thanks very much. It's a great pleasure to be back to Haifa, where, as Deborah already mentioned, I taught an intensive course a few years ago on international economic law. Also, the book that she mentioned on Leo Strauss, I had the opportunity to present not once but twice at Haifa, and I have very good memories of those experiences. So it's really a pleasure to be back here. So the paper that you have today is an essay that I've co-authored with an Egyptian attorney, and we wrote the first draft while he, Amin Yacoub, was an LM student at NYU. And the broad question that this paper raises, which I think that we should focus on today, given that this is an interdisciplinary forum, is the question of what happens when investors or investments operate in conflicted areas and are subject to non-state violence or the risk of non-state violence. To what extent should the host state take responsibility for compensating investors for the losses from such violence, or ideally take precautions, and what kind of precautions to prevent such harm from occurring? And the paper focuses on one particular dispute in international law, and this is a dispute under what is called the bilateral investment treaty. Now, these treaties have become a highly controversial topic in international law because essentially what they allow for is an investor to sue a state if the state has failed to provide certain levels of protection to the investor. And some of the provisions in these treaties are very broad. One of them is fair and equitable treatment. Another, which is involved in this dispute, is full protection and security. This leaves a wide range of meanings that an arbitral tribunal could possibly adopt in interpreting what, in fact, is the obligation of the host state to the investor. But if the investor manages to convince an arbitral tribunal of liability, then they can be, then the host state can be responsible in some cases for tens, if not hundreds of millions of dollars in damages. And these arbitral awards can be enforced throughout the world, either under the New York Convention or the Washington Convention, where all of the signatories bind themselves that their domestic courts will recognize and enforce an arbitral award, provided that the appropriate rules and procedures have been followed. So this is a powerful tool that investors, that corporations can use against states, and they've often been using it to challenge regulatory actions that states have taken that disadvantage the investors. And one example is renewable energy in Spain. Spain had a very generous subsidization program for providers of renewable energy in order to meet Spain's and the EU's climate change or carbon emissions goals. And then Spain discovered that it was paying too much in subsidies, that it was causing too much of a drain on its budget, and that probably it could achieve a similar level of electricity generation with lower subsidies. Spain cuts the subsidies, and the investors begin to sue under these kinds of treaties. In the case of Spain, it was something called the Energy Charter Treaty. So you can see why they would be controversial. But unlike those cases which deal with regulatory change and whether a state should have to incur liability to an investor whose economic interests are disadvantaged by regulatory change, this dispute raises a different kind of issue, which is a much less frequent one, which is, what does it mean for a state to undertake an obligation of full protection and security to an investor? And particularly in a context where the investor is going into an area, a region where there is an ongoing conflict, where there are conditions that could be called conditions of a failed state or fragile state. And so this brings us to the factual context of the dispute. So you all know about the pipeline that carries gas between Egypt and Israel. The investor who was involved in this dispute was a corporate structure of which Ampal, the formal name of the claimant in this case, was a part, that operated the pipeline and entered into contracts for, at the time, the supply of gas from Egypt to Israel through the Sinai. Now, two footnotes. This case never went to the point at which the tribunal assessed damages, because this corporate structure ended up in a situation of bankruptcy or insolvency. And second, while the facts of this case are about the gas going from Egypt to Israel, in fact, the future of the pipeline may well be the other direction, taking Eastern Mediterranean gas, that's basically Israel's offshore, into Egypt. So this is one reason why ultimately the case may be settled, because all of the affected parties now have a new kind of interest in making the pipeline work. So I use this case as an example, and not to suggest that ultimately that in this instance the investor will actually be given this amount of money. It will probably be settled between the Israeli state, the Egyptian state, and the company, so that they can effectively use the pipeline going forward as part of the Eastern Mediterranean gas network. So that's on the policy or practical side. But the normative issues that are raised by the case are actually, I think, quite important. And I'm not going to emphasize the detailed legal analysis, because I know not all of you are lawyers, much less interested in the arcane features of international economic law. But I want to give you an idea of how the law intersects with some very difficult policy questions in this area. So the norm in the treaty under which the investor was suing, as I've said, is full protection and security. What does it mean for the host state to provide, quote unquote, full protection and security to a foreign investor in this kind of context? And as you can appreciate, I mean, full protection and security sounds very vague. I mean, one meaning could be what we would call in private law absolute liability, which is that the occurrence of an event that harms the security of the investor would itself be a trigger for a payout by the host state. And I think it's fair to say that most tribunals, even though only a few of them have interpreted this particular treaty language, and most academic commentators do not approve of an absolute liability approach. And you know, from a public policy or law and economics point of view, you could easily understand why, which is moral hazard, right? You know, if you have absolute liability, it's like an insurance policy without a deductible. It reduces the incentives of the investor to take their own efficient precautions to provide for, you know, security, assess risks to physical infrastructure, personnel, and so forth of the project. So I think most of the discussion on this starts from a rejection of absolute liability as the appropriate standard of protection, which, as I say, would be like an insurance policy without a significant deductible. So if it's not absolute liability, what is the nature of the obligation? What are the measures or precautions or responses that a state is obliged to take by the obligation of full protection and security? And the critique we make of the arbitral tribunal that ruled in this dispute is that they never really analyzed that question. They simply said that the host state was subject to a duty of due diligence. But due diligence only suggests, you know, a level of conduct or activity towards fulfilling an obligation. It doesn't tell us exactly what the obligation is. And that's where I think the tribunal here let down, you know, the cause in a way. And so in the paper, we suggest a range of considerations concerning international law that might affect our understanding of what is the duty of the state. I mean, one consideration is countervailing economic norms, such as human rights. I mean, certain kinds of measures to prevent, you know, attacks on the security of foreign investors could themselves be violations of international law norms of human rights. So a second question is, what is the priority in a situation of emergency or conflict? Is the first priority of the host state to its own citizens, which is in a way what human rights law, you know, would suggest in these situations? Or is the first priority to foreign investors? Or should we have a non-discrimination principle where the protection that's provided to foreign economic actors is provided on a non-discriminatory basis? The protection provided to domestic economic actors, excuse me, is provided on a non-discriminatory basis to foreign investors. And some treaties limit the obligation of full protection and security to a non-discrimination norm that says that the host state cannot provide a lesser level of security to its own to foreign investors than it provides to its own nationals. But again, that could come afoul either of domestic constitutional law or human rights law to say the state has to, you know, to provide equality of treatment, that it can't favor the security of its own citizens against that of foreign investors. So that's one set of issues that would need to be grappled with to really understand what within the universe of international law is meant by the obligation of full protection and security. Another relates to the moral hazard problem I already discussed, which is voluntary assumption of risk. In other words, what level of risk do we expect the investor themselves to assume, such that it's not imposed on the host state? And this goes particularly to the context of this dispute, which was the Sinai, largely, roughly between the time of the Egyptian Revolution, the overthrow of Hosni Mubarak, through the Morsi period, and the reestablishment, and just before the reestablishment of a new dictatorship under Sisi. So during this period, and this is where Mr. Yacoub has been, very diligent in doing research in Egypt, I think it's fair to say that there was a situation of considerable fragility and instability within the Egyptian military and security services. And at the same time, if anything, a heightened degree of violence and insecurity in the Sinai, the area where the pipeline was located. So a couple issues emerge from these facts. I mean, one is that already when the pipeline project went forward, it should have been known by the investor that the Sinai was not a quote unquote safe area, that at various points in time, it's fair to say the Egyptian army and security services did not have effective control of the Sinai, which would mean, and we could debate what it means, that's an interesting question itself, but it would certainly mean a reasonable ability to ensure that acts of private violence against an investor of a serious nature, such as bomb attacks, could be prevented or foiled if they started to occur. So, do we relativize the obligation of full protection and security on the one hand to some assumption that if the investor is going into a conflict-ridden area where notoriously the state does not have full control, they wouldn't expect the state to provide full insurance against this kind of violence? And secondly, what do we expect the state to do? Should that be related to reasonable assumptions in the particular circumstances of state capacity? Now, why in this particular instance did the tribunal find that that Egypt was liable, albeit based on this vague notion of due diligence? Well, first of all, the tribunal reversed the burden of proof and basically said that it was up to Egypt to prove due diligence. And that's, of course, in a situation like this, very difficult to do. And one of the reasons it's difficult to do that I think raises important policy questions about full protection and security is that, I mean, most states and their militaries and security services don't necessarily want to provide full information about all their capacities or the limits of their capacities, right? I mean, you're giving important information to your adversaries if you basically say, okay, this attack was not prevented because, we have a weakness, a strategic weakness here, or, why were troops not sent at a given point to a certain place? Why did they not respond to intelligence? I mean, these are not the sorts of things that that states and their military security establishment generally like to broadcast publicly. So if you reverse the burden of proof and this kind of detailed information is not being provided by the state, then by default, in a way, the investor is going to be successful. And you might say, well, why couldn't the information be provided in confidential form to the tribunal? And here, the fact is there's no real security in these international arbitral tribunals. I mean, they operate outside of the state context. And, frankly, they're fully hackable, really. I mean, they don't have any sophisticated security service or counter cyber attack facility to support their work. There's the reversal of the burden of proof. Also, these arbitrators are mostly, commercial lawyer types, or come out of, even if some of them are professors or public international lawyers, they get appointed to these tribunals because they become prominent in the field of international investment law. And that field, in a way, is centered as a practice area on large commercial law firms that do multiple arbitrations for big companies, often oil and gas companies. So, they don't come from the security world. They don't really have much of an ability to assess these kinds of facts. So in the paper, we talk about, the smoking gun, which convinced the tribunal that Egypt's, the Egyptian state could have prevented some of these attacks and simply didn't do anything about it, which was that in one particular case, there were a few Egyptian soldiers who actually were near the pipeline at the time at which apparently they were given information that some explosives were going to be detonated. And the Egyptian soldiers did not show up at the pipeline. So to the tribunal, that was just, a sign of an obvious lack of due diligence. But when it comes down to it, it was kind of they had a Hollywood vision of what would happen, that these soldiers who just happened to be hanging around, we don't know if they had any, ability to deal with explosive disposal or the kinds of fallout that might happen. Any anti-terrorism training would rush in and in the middle of the explosives being detonated and prevent an attack. So that was the image of the tribunal of what should happen. And it's just a very kind of crude, thriller movie type view of the complexity of, maintaining security in the region and the way in which soldiers might be deployed or redeployed in a real-time basis. And so to our mind, this doesn't just point to perhaps the rather naive way of the tribunal conceived of the security situation of the Sinai, but also to the limits of using investor-state arbitration to assess state liability for the prevention of non-state violence to investors in conflict-ridden areas. And so in the conclusion, we kind of suggest that maybe as a policy matter, it would be better to rely on political risk insurance, because one of the objections to the argument that states should not be responsible is that states take no responsibility, then you won't get foreign investment in these areas. And to rebuild a society and perhaps try and move beyond conflict, you could argue that having foreign investment, bringing in foreign capital, know-how, improving infrastructure is a positive thing. Well, in reaction to that argument, the World Bank Political Risk Insurance Facility, MEGA, the Multilateral Insurance Guarantee Agency, has in fact provided a special insurance facility for investments in fragile and conflict afflicted states. And basically, this gives an investor some protection against risk without making the host state liable. And so it reduces the disincentive to going into a risky area while not imposing inappropriate or unclear or vague obligations on the state to protect the investor in a very complicated and high risk security context. So I think I stop there, and I welcome discussion. And again, I know we're in an interdisciplinary setting, so I'm happy to talk about the policy issues surrounding the dispute, and we don't necessarily have to go into a lot of the legal analysis about investment law. So the floor is open.
You have a mixed audience, so you have.
Right. Well, I'm happy to obviously talk about the legal issues as well. Yeah.
All right. Thank you very much for joining us today, and I really, really enjoyed the paper. It's also an award that I teach to my students under the topic of the Articles of State Responsibility, because of the reference made there, and I kind of was a little bit taken, or I was. You seem to be attacking it in a very direct way, and I was kind of considering whether it should stay on the syllabus or not, giving your arguments. But more to the point, so there's a number of issues. I think towards the end of so I think a central issue in the paper is the distinction between obviously full protection and security and fair and equitable treatment. So towards the end of the paper, you argue that while Egypt has not kind of failed to perform on its obligation to provide full protection and security, it may have indeed not granted Ampal fair and equitable treatment. And I think that part of the question, that I remain with, I think the main question is what is indeed the difference between those two standards, and why would it make a difference to cabin the issue here rather than there? I think that would be. I mean, I kind of totally see that it might be my own lack of expertise in this area that leads me to ask this question. But still, it seems that it's not entirely clear if you give these examples that it seems like Ampal was discriminated against because it is an Israeli enterprise. And so, is that all? Can that not be cabined under full protection and security? Just as it is under fair and equitable treatment, and what difference would that make? I guess I have a few more points, but I guess we'll leave it there for now.
Well, I think that goes to my initial question of, how we consider full protection and security. Is it in a way only an obligation not to discriminate against the foreign investor in relation to domestic economic actors, or is it a form of liability that creates that is indifferent to whether the treatment might be better, worse, or the same as domestic economic actors? And to my mind, under fair and equitable treatment, there is less of a less of a normative problem if you read fair and equitable treatment relatively narrowly or in a circumscribed way to suggest some kind of impropriety in state action. In other words, misfeasance of some kind. And under fair and equitable treatment, I don't think that merely failing to take a certain precaution, unless there is a discriminatory or political intent, inappropriately political intent, would constitute misfeasance. But for example, inciting or adopting, to use language from the ILC Articles of State Responsibility, the actions of the violent actions of non-state actors, would definitely engage responsibility for a violation of fair and equitable treatment. The question here is whether, through part of the time in question, the reaction of the Egyptian state was connected to a considerable amount of anti-Israel animus that was perceived to have increased in the early part of the Morsi era, or at least to have been publicly unleashed more so than in the previous period of Mubarak, although it was probably already there. To what extent that could have motivated or influenced the individual decisions of the Egyptian state about the protection of the pipeline. Now, the fact that the animus might be there and might be shared by certain actors in the Egyptian state or military would not necessarily in itself engage state responsibility unless there was some causality, unless it actually affected the relationship with the investor and the treatment of the pipeline. And again, we've gone through these facts extensively, and Mr. Yacoub has much more access to material, in Egypt, and as somebody who, is a native speaker and reader of Arabic and so on, and he's gone through a great deal of material. And I think the answer is yes, there was such an animus, and yes, it did extend to elements in the Morsi regime particularly. But when we look at the day-to-day relationship between the pipeline operators and the Egyptian military and security services, it doesn't seem to have, affected terribly much the relationship. In other words, at numerous points, they had discussions about precautions to take, and the military made recommendations to the pipeline about improving the training of their own security personnel and certain security protocols and so on. And there doesn't seem to have been ill will. There seems to have been perhaps a certain amount of incompetence, or that the Egyptians did not place an enormous resource priority on the pipeline and expected the investor to themselves pay a significant amount for security. But and again, you're going through a lot of material about this that discloses this relationship. If the burden of proof, as it normally would be in international law, were on the claimant, I don't think they could meet the burden of proof that some kind of animus, even if it existed, was influencing on an operational basis the relationship between the operator of the pipeline on the one hand and the Egyptian military and security services on the other. But I think our point was also a different one, which is, and maybe what you're asking in a way, is could this whole dispute be framed more as a dispute about fair and equitable treatment? And here, really, I think the baggage is one of state responsibility and attribution, because fair and equitable treatment requires attribution to the state of the underlying conduct. Here, the underlying conduct is by non-state actors. So where you get to by full protection and security is a kind of legal clarity that even apart from attribution under the ILC articles, the state will be responsible for a failure to take precautions to prevent or to foil or reduce the harm from this kind of non-state conduct.
That makes sense.
Okay. Say for the phrase of full protection, I'm leaving it aside for a moment. There is no full protection. It has to be reasonable. There is no such a...
Exactly, which is why it's such a hard norm to interpret.
Okay. If you are trying to see the text or the language, so we have full protection. But I don't think that this was the intention really, because reasonableness and proportionality should also play a role when we are interpreting this. But as I said, let's leave it for a moment. In this case, what is ironic is that all the players, including EMG, Ampal, let's remember, Ampal is a shareholder having 12.5%.
I know, yeah.
So the ironic thing is that all the players, EMG and EGPC and the other one, all are Egyptian players. So from the interest of the Egyptians, they should act in a way that will secure their assets. It's Egyptian assets. when we say איך זרים? aliens?
Foreigners.
לא, נוכרים או... אוקיי, בסדר, לא חשוב. הוא שמה, כתב משהו אחר. אוקיי, never mind. So what is ironic here that we are talking about impartiality and other stuff of this, where the basic thing is that the entities that are at play are Egyptians. This, in my view, makes the situation even worse, because Egypt, as a sovereign, by the way, I haven't seen this term in the paper, as a sovereign on the Sinai Peninsula, should have acted with full, let's say, rigorous and effort, because they are the sovereign, in order to defend Egyptian assets. Now, if they're not doing it, this by itself shows how negligible the Egyptian army was. The Egyptian army, how negligible they were. Negligible, sorry. How negligible they were. And I'm not talking about, this story of a couple of soldiers. I'm talking about the general trend. How can you understand the situation that the sovereign is not protecting his assets? Secondly, in the arbitration, there are two periods. The one is the outbreak of the Arab Spring.
Yes.
Until Morsi came to power.
Yeah.
And we have afterwards the second phase. The arbitration said explicitly that for the first phase, they are not holding Egypt responsible, only for the second stage. Now, if you look at what Assisi did when he came to power, he deployed thousands of soldiers in Sinai with the permission of Israel, backed by the United States. This was something that could have been made before, and it wasn't. So this raises a very big question. How can it be? So I think that all in all, and say for the full protection, that there is no such a term, full protection. The Egyptians were negligible and reckless, and they did what they should have done with their assets, Egyptian assets, under the sovereignty of Egypt. So there is no question in my mind that they failed. They failed, and the argument that they won't reveal secrets, security secret, because of cyber means that cannot protect, etc., secondary, even more than secondary, treachery to the main point that the Egyptian army didn't conduct itself as a sovereign should guard its assets. Now, in a way, we think that the problem is Ampal vis-a-vis versus the Egyptian. No, Ampal is only a shareholder, a little shareholder, but he suffered, of course. By the way, EMG, as an Egyptian company, sued Egypt in a court in Egypt, and they award to the benefit of EMG against the Egyptian government. Yeah. So all in all, you see that there is no question about what should have been done and what happens de facto.
Well, I mean, I have a number of responses. First of all, under international investment law, a shareholder has standing to bring a claim. So there's no question that Ampal had American nationality, because otherwise there would have been a jurisdictional objection, because under a bilateral investment treaty, an investor cannot sue their own state. So Ampal's nationality would have to be established. But that's why I used, when I gave my presentation, the expression that Ampal was part of a corporate structure, to indicate that there were a complex group of corporate actors involved. And in fact, there was an additional suit, which was a contractual suit in the ICC, an international arbitration for breach of contract in Paris. Yeah. So there were these various lawsuits, but the question of principle that I'm raising, I think, is, you said that with 2020 hindsight, we know now that had the Egyptian state wanted to adequately prioritize the protection of the Sinai, that they could have rallied a sufficient number of troops, to do it. We read a wide variety of literature about the state of the Egyptian military and the politics of the Egyptian military, in the transition between the revolution and the Morsi period. I mean, we have to depend to some extent on scholarship of experts who, are, not international lawyers, but who study what happens to the Egyptian military. And there's a lot of evidence that, the political and strategic situation in Egypt for a certain period of time would not have made this a very easy thing to do. But you may be right that if this had been the number one priority and there was enough political will, then it might have been done. But this just, to me, raises the question: what is the obligation to the investor in relationship to other priorities of the state? Does it mean that, and so here, this question is avoided by using the expression due diligence. Well, what's due diligence? I mean, you suggest that at some point, Egypt could simply have thrown enough resources at it that they could have essentially secured the pipeline. But, that's more than due diligence. It's like, saying that if we abstract from all their considerations, they had enough force to basically protect a pipeline. But is that the right standard in international law to hold them to? I mean, this is, I think, both a legal and a policy question, because it has to do with, in some sense, what we think the proper assumption of risk by the investor is in this situation. I mean, it's uncontroversial that the Sinai was a very dangerous place through this period. I mean, that, it seems to me, is uncontroversial. It's also uncontroversial that the investor went in there knowing that there was a high level of risk. Now, does this, I mean, to my mind, these factors suggest that the obligation of the state has to be relativized to its other, priorities. It is very difficult to assess, whether how much risk is reasonable for the investor to assume in these situations and how much is reasonable for the state to assume. And this is one reason why the answer may well be to operate through, political risk insurance.
Not so much. I'll tell you why. Because I've looked into the policy of MIGA. And in the policy of MIGA, by the way, MIGA is not, they have their quotas, they have their policy, they have their criterion for accessibility, etc., etc. But what is very important in MIGA, they have the clause of subrogation and assignment. In other words, if the investor, or in this case, EMG, not the shareholder, EMG had made or had establish a policy under MIGA, and MIGA is liable to pay to Ampal, then the insurance agency has the right to recourse to the Egyptian government by the subrogation. So from the Egyptian point of view, I don't see any situation by which they can, free themselves from their sovereign duty to guard Egyptian assets. If we look at it in a more, remote conception, it brings us to some absurd, because the sovereign will not, will not defend its assets. So what assets should he defend?
Well,
the government.
The pipeline was not owned by the government of Egypt.
What?
It was not owned by them.
What?
The pipeline.
No. No. EMG was a government. It was a government, an Egypt government company. They had a special tax benefit of 0 in 2005. In 2008, the Egyptian opened the contract and raised the tax rate to 20%. And at the first place, why they gave EMG the 0% benefit, tax benefit, was because they thought that this is very beneficial to the Egyptian economy. By the way, the pipeline is not only to Israel. The pipeline goes to Jordan,
yes,
and to
I
Saudi
know,
Arabia.
for the purpose of presenting the policy issues and legal issues in the paper, I've left out a lot of the the detail, and some of it is in the footnotes and so on. But I think there's a danger of not seeing the forest for the trees. I mean, the pipeline was not an asset of the Egyptian state. It wasn't a state. It wasn't like part of the military or the state infrastructure.
It was an intention. It was from the outset. This was the solution to sell gas to Israel without direct involvement of the Egyptian government.
Yeah, exactly.
There was an intermediate.
Yeah. So I mean,
but still, they were an Egyptian company.
But also
incorporated in Egypt with the offices in Cairo.
Right, but from the point of view of the legal and policy question that I'm trying to answer in this paper, I mean, the first thing that I note is that it would be wrong, entirely wrong, to characterize the Egyptian government as doing nothing. I mean, the Egyptian army and security services had ongoing consultation and cooperation with the people running the pipeline and the pipeline's own security personnel. I mean, it wasn't as if the Egyptian government did nothing. I mean, it was there were at several points a serious concerted effort to address the problem.
But if you take 13 attacks,
Why should I show this?
Yeah.
okay.
I mean, I guess that the question is, who is the judge?
It's interesting.
You have a different perception than I do, based upon admittedly research that I've had to rely on other experts for to some extent. But is the role of an arbitral tribunal mostly of people coming out of the commercial law world to decide whether, given 13 attacks, there could have been better cooperation between the Egyptian army and private security personnel? I mean, I don't think anything that that you would be doing in the commercial law world in London or New York would equip you to solve that disagreement between you and I about what seems reasonable in these circumstances. Now, I want to respond also to the MIGA issue, because I've actually written an article about how MIGA functions. The fact is that MIGA has only, I believe, in one case resorted to subrogation, which was against Argentina, I believe. In all their cases, MIGA has intervened in some ways to settle the disputes without paying out.
six times they paid. 6 times since 1988. They paid
Yes,
6 times.
Yeah, but I think in only one case they went to subrogation.
I don't know.
Yeah, but they rarely paid out given the number of contracts. And so, also it's not insignificant that they have a special program for fragile and conflict affected states. And I say that's not insignificant because in a way they're explicitly taking on, a role of risk spreading in situations where the state itself may have a limited capacity to protect the investor against certain kinds of risks. And again, I'm going to rely on that other research that I've done about MIGA and suggest that the World Bank has developed a fair amount of competence in managing these its risk exposure under these insurance arrangements without having to resort to recovery against the state in question. But of course there is at least that one exception, and as you say, in a few other cases, MIGA has ended up paying out something. But its record of not having to do that is pretty impressive.
Really?
Thanks for the paper, and right, it has the broad question and the specific of the case, and I'll start with the broad issues, and perhaps I'll say something about it. So first, I think that in the title you mention conflict zones, and I wonder what's the definition of a conflict zone for you. So if we look, for example, at the Sinai in 2011, is it a conflict zone? So I'm in a case I started as an IHL person.
Right.
And I'm not sure what type of armed conflict do we find in Sinai in 2011. Right? It's clearly that as you suggested in one of the sources in your footnotes, you refer to a research, and there was no violence against the Egyptian police prior to 2013, and the attacks were in 2011. So we don't have any armed conflict between the Egyptian government and the militants in Sinai. Perhaps there was a conflict between Israel and those militants. I don't think so. And so is it the instability after the Arab Spring? So I would like to hear more about how, for your purposes, how do you define conflict?
We have not used the concept of conflict in terms of the international law of armed conflict here. We have relied on international security literature, national security literature about the situation of the Sinai through various phases, of the relationship between the investor and the host state. I think, all I would say is that, there were repeated acts of non-state violence in the area, through the whole period and even before, and a pattern of these acts being organized by groups, and so, but everything is relative, right? So, is there a perception of a heightened level of insecurity to which the state that, as has been pointed out, is ultimately the sovereign, does not seem to be able to or adequately responding to? But all of these are relative, criteria. But I would say that in terms of the frequency of these attacks and the perceived inability or ineffectiveness in stopping them over this whole period of time, we haven't seen much dissensus in the security studies literature about the notion that there was a high level of danger and of non-state violence in the Sinai. Again, this is where interdisciplinarity comes in. I'm an international economic lawyer. I'm not a security studies specialist, and and the same is the case for Mr. Yacoub. So we've relied upon a wide variety of literature that assessed the situation of the Sinai at different points, most of it from security studies and area studies experts. And I don't think we found a single study or article that was unwilling to characterize the Sinai as a very dangerous place or conflict-ridden during this whole period of time. And so when I don't see dissensus in literature that's produced by, academics with considerable reputations in area studies and security studies, I don't worry so much about characterizing it as a conflict zone. I mean, if the experts were significantly divided about whether there actually was a really high level of insecurity in the area, then I would worry more that I have to delve further. But the experts do not seem to be divided. So, I mean, the paper is not published yet. If there are other experts that we're missing who actually think the Sinai was, reasonably safe and not afflicted by repeated episodes of non-state violence that were perceived to be, a regular risk that was not being, adequately or effectively controlled or managed by the Egyptian state, then we would definitely take into account those reports or those studies. But we never found one.
I'm interested in the broad standard. So I don't think that it wasn't dangerous, but I'm just curious.
But we're not drawing it from international law. So I understand the debate about an international law, about what is an armed conflict, what is an internal armed conflict, what is an external armed conflict, and how that relates to the law of war, international humanitarian law. There's another scholar actually who kind of was the intermediary who kind of got me involved in this talk, Ira Rick Laukman, and she's writing exactly about that topic, about investment law and armed conflict, and she's assessing the legal standards from international humanitarian law. I mean, we talk a bit about the human rights implications of security operations in this paper and the human rights obligations of states to their own citizens. But we've avoided the topic of IHL or the law of armed conflict because I think that her work is going to go really in depth on this question.
So would you define, for example, a very dangerous neighborhood, lots of crime, as a conflict zone for the purposes of investor-state arbitration?
Well, take the example of the country Colombia. Right, so there are parts of Colombia where that are both violent but largely have not been controllable in the past by the state, where the state doesn't have effective control of the situation. So I think there are two dimensions to this idea of a conflict zone. One is that there's a high level of organized violence. That's one, and two, that the organized violence that there's a perceived lack of effectiveness of response of the state. So the risk of this violence is kind of endemic because of the limited capacity of the state, or perhaps just competence or will of the state to control the area. I mean, and again, we have to ask, what does the definition do in this instance? I mean, what does it do? It raises an issue, first of all, about voluntary assumption of risk. That if we know that the state has had limited effectiveness in controlling the violence, and we know that it's something that's repeated and frequent, and perhaps for the time being endemic, and the investor goes into the area, well, should they not be assuming some of this heightened risk themselves? But I want to be careful here that this characterization is not. In the paper, we're not using it to trigger the applicability, for example, of any specific body of international law, or to make an argument for emergency powers or anything like that. We're basically, we could just call it high risk, or heightened risk. And so similar questions might be asked even without the violence of non-state actors about climate change, going into a region that's dramatically affected by climate change. How much protection does the investor expect from the state? What are the limits of what the state can do, both scientifically and economically, for climate adaptation? So there's no magic here to the expression conflict zone. It's really an attempt to bring the reader into a situation where there are heightened risks and limited resources or capacities of the state to bring those risks down to some kind of normal or or ordinarily manageable level.
Maybe just two broad questions. One is, you talked about moral hazard and strict or absolute liability, but we know from private law that we can have strict liability with contributory negligence.
Right, and so that's why I use the expression absolute liability, because strict liability with contributory negligence is one notch below absolute liability.
But you still do not adopt or call for an approach of strict liability plus contributory negligence, and you're closer to a negligence principle. And I wonder if the moral hazard argument does not apply to strict liability and contributory negligence, and maybe it will result in different, result in a specific case. So what's the argument against this position of holding
Well, I think contributory negligence is not fully reflected in the concept of moral hazard. Why? Because moral hazard represents a situation where the failure to take precautions is reasonable, because somebody else is basically insuring you against the risk. I mean, in a way, it begs the question. I mean, if we had strict liability with contributory negligence, then what would we be saying? We would be saying that even if the state takes many precautions, that the failure of the investor to take certain precautions would reduce their recovery and therefore limit in some way the liability of the state. So we'd be making an ex post judgment. But I also want to be able to make an ex ante judgment. In other words, to say that, and this is why it's not purely a question of moral hazard, it's also a question of whether there's a voluntary assumption, of certain levels of risk. And to my mind, if investors are making decisions about risk and return, and they're looking at investing in different places, they should be considering, this is what I mean by the ex ante perspective, not just whether ex post we assess a failure to take precautions once they've decided to enter into the project. Ex ante, they look at risk and return, relative investments in different places. And there's an inefficient allocation of resources if the investor does not ex ante factor into their investment decision, to some extent, that the higher level of risk in going into a place like the Sinai than somewhere else. Now, they may say, well, we're still going to go in. And so if we want the investor to privilege the project because there's a public good, then we should be subsidizing the risk insurance. But who should be doing it? Should the subsidy come in the form of a treaty obligation to any investor who comes in, or should it come through a contractual obligation or through political risk insurance? And by the way, as we were discussing, there was also a contract in this case. I mean, the another way of doing this that's an alternative to both treaty protection and political risk insurance is to do it through a contract where there's an understanding, an explicit ex ante understanding between the state and the investor, that the state is responsible for certain kinds of protection measures, and then the firm is responsible for engaging competent personnel, notifying the state of security breaches, having routine examinations of the security features of the property. The state might be responsible for patrolling the perimeter and so on. So you nail down the responsibilities of each side in the contract, and this happens. So I think that I'm not against that. So if it's efficient to allocate more of the responsibility to the state and less to the investor or vice versa, I have no problem with contractual bargaining to such an outcome based upon as full information as the parties have. And like political risk insurance, I have the feeling that is a more manageable approach than a very vague obligation like full protection and security, which involves a set of arbitrators who are almost never have any expertise in security matters, making a judgment call as to whether the state did enough or the investor did enough and so on.
I don't want to take. So just regarding your position regarding the burden of proof, I find this position a bit concerning if we look at it more broadly, right? Because the question is who holds the information, and if in such cases, this is a case where the government has all the information. The investor cannot know what type of security measures the state takes. So if we say the burden of proof is on the plaintiff and everything is confidential, then there's no way that they will be able to establish, in any case, that the state did something negligent in terms of so actually, right, either flipping the burden of proof makes sense here because the state holds all the information, or to have some kind of obligation towards transparency regarding the steps that they took. But you suggest in the paper that it's not reasonable to demand from the state to actually reveal their policies. So if it's not reasonable to ask them to reveal their policies, and the burden of proof is on the plaintiff, then in 0 cases will they be able to establish the state acted violating the due diligence obligation.
Well, I don't think in 0 cases at all. First of all, the normal rule of international law is that the burden of proof is on the claimant to establish the facts that would prove their claim. I mean, so I start from that position. I mean, so you say we reverse it here because the state has all the information. Well, I would say 2 things. To my mind, the state shouldn't have to disclose all the information. And secondly, I think there are instances where one could imagine the prima facie burden of proof being on the investor, and them establishing, for example, that that they repeatedly warned the state that they were worried about security breaches, and the state was entirely unresponsive. That's not the case here.
But then you take you refer to the smoking gun incident, and you suggest that, okay, there could have been lots of reasons why the soldiers. But if we look at the burden of proof, so they established that they called the Egyptian army and they did not respond. Isn't there now a burden of proof on the Egyptian army to explain why they didn't respond. So you raise several hypothetical. Maybe they weren't equipped enough. Maybe they were.
But should they be revealed?
Can't Egypt, right? But you do not.
But I'm explicitly giving you a reason why they shouldn't do it, because do they want to reveal to the insurgents or terrorists their incapacities? I don't think they want to reveal that publicly. So I totally understand why Egypt would not come along with an explanation as to why those soldiers didn't arrive. I mean, it would be broadcasting perhaps the weaknesses and defects of particular deployments of their soldiers, and that could easily be exploited by the other side. But nothing you've said seems to me to I mean, you've given the other side of the coin, as it were, but maybe this just points to the answer of something like political risk insurance.
But here also, right? I find it puzzling.
By the way, another possibility, I mean, there are different models. In Canada, the government of Canada just bought a pipeline. I mean, another solution to the information asymmetry problem is for the state to actually own the pipeline and take responsibility for it, and then have contractual arrangements with others for the supply of the gas. So there are a number of ways of allocating or reallocating the risk. I just don't think that a general obligation like full protection security that's interpreted by commercial law arbitrators is a good way of risk allocation. But when there are others, like political risk insurance or the state itself owning the pipeline and protecting it as a genuine state asset because they own it and it's part of the state, and then having the pipeline, the state engage in contracts for the use of the pipeline for the supply of gas. I mean, we would have to think through the policy matrix of state ownership versus private ownership of infrastructure that raises serious security risks. And at a certain point, the security risk should be such that it might be better for the government actually to own the asset.
So back to, I guess this is somehow back to square one in terms of full protection and security. So as you describe in the paper, there is a kind of relationship between the standard here and a very familiar standard from international human rights law, namely that the state has an obligation to, even positive obligations towards everyone in their jurisdiction. And you bring the source from Batel, or I think, talking about a kind of obligation towards asylum seekers, pre-refugee law.
Yeah.
And so that seems like if we want to give, if we still resist kind of disposing of the entire standard of full protection and security, that seems like a standard that might be not so difficult to interpret, namely that even when there's no causal link between an action or an omission of the state as a fair and equitable treatment argument would require, there still is a positive obligation to give certain protections to anyone under the jurisdiction.
Absolutely.
And so would that be a productive, constructive way of just kind of cabining this full protection and security doctrine within quite limited framework that would make sense?
I agree. And I think that in a way, if you have an obligation of full protection and security, an obligation of fair and equitable treatment, it probably extends to that kind of minimum standard of treatment that's enjoyed by everyone who is, under the protection of the state. And so, that's why I think that I'm more sympathetic to treaties. And there's an interesting case, Lessie in Algeria, where the investor invested in a part of Algeria where there was an active insurgency. The tribunal said we have to relativize the responsibility of the Algerian state to to its capacities given this localized insurgency. But the obligation of the treaty in that case was a non-discrimination obligation. In other words, the obligation of fair and equitable treatment is an obligation to provide some protection on a non-discriminatory basis. So by virtue of being within the territory of the state, the investor, along with everyone else, is entitled to the same level of protection. And I really, as a matter of principle, have no objection to that. It also is more of a focus on what a lawyer can assess, which is not so much what is the absolute level of protection the state ought to be providing in a very complicated security situation, but whether some people were, provided with some protection and others in a way that can't easily be explained were not provided with that kind of protection.
Right. So if that's the case, is a lot of what's going on here actually which might be part of a larger argument, I don't know, an idea that really protections for investors should be highly relativized and very sensitive to the particular circumstances of every developing state in which they want to invest.
Yeah, and so you can do that by contract and political risk insurance, which is a form of contract that allows for a reallocation or spreading of some of the risk to a third party, which has, by the way, if it's an organization like the World Bank, it has important information itself about many of these situations.
So here's my last point, which is, if that's the case, then isn't the proposal to focus so much attention on risk insurance and to give so much weight to this particular policy proposal, doesn't it have the kind of foreseeable results of really increasing the demand for political risk insurance?
Exactly.
And then really affecting the price of political risk insurance and the way that the structure of the market of that particular product around the world, in a way that would have some I don't know if desirable results on particularly those developing states that you want to be sensitive to their circumstances.
Right. So this is, this actually, that's a very helpful question. And it relates to another study that I've done, co-authored with a different person who's more of an economics, political economy, and IT guy, on how we should view investment protection in least developed countries. And obviously Egypt is not one of these, but a lot of the fragile and failed states are least developed states. And so we think that there is an argument, if there is a public good that is created by foreign investment, like the provision of infrastructure that would otherwise not exist, that there's an argument for a subsidy, just to reflect that public good. So in this other paper, a different co-author and I argue actually that some foreign aid, including multilateral aid, should be converted into subsidized political risk insurance in these kinds of situations where we really want the foreign investment is important. The risk is very high, and if you were to price a political risk insurance product and provide adequate supply, you would be, in a way, pricing out of the market projects that would be very positive for the development of that region or that country.
Exactly. Yeah.
So, and I think you could get a lot of development benefit out of subsidized political risk insurance, because unlike normally development aid, where some government agency in one country and international bureaucrats are trying to decide what project will work or not, in this instance, you already have parties who want to make an investment, who are assessing it from both a private party and a state point of view, and then you bring along a third party like the World Bank or another development bank that has a lot of information about the region. Well, and it's only a subsidy. I mean, there's still a part of the premium that is being paid, and that goes again to moral hazard, and you want the firm to pay something for the added risk. But you also, if you want the project to go forward, you might have to subsidize the political risk insurance. insurance.
Right.
But another issue you raised, which reminds me of some of the discussions that I had when I was doing the research about MEGA. I went to MEGA and talked to them. And I, we kind of, with this further third co-author, we sort of asked them, like, MEGA really works because you've increased the number of political, the amount of political risk and coverage over these years, and yet your model, your business model, provides for full cost recovery for the World Bank. The World Bank is cost nothing by this. Have you thought about expanding it? And what they told us was interesting. That for a long time they had a lot of caution because they did not want to present themselves as aggressively competing with the private sector. So they would have a website, and people in the know would come to them, and it's not as if they didn't want to write the insurance; they wanted to write it, but they weren't out there as salespeople, and they suggested that's changing, and that they're becoming interested in more. Aggressive would be the wrong word, but in spreading the word and in increasing the number of special facilities, like the facility for fragile and conflict affected states, and possibly introducing other areas where there would be an aspect of subsidization or aid that's provided.
Fascinating. I think it was a really interesting article and a fascinating discussion.
Thanks.
Many thanks.
Thanks for your excellent comments, which will be extremely helpful in developing the paper to the point of publication. And again, a pleasure to be back in Haifa.
Pleasure to have you.
Thanks.